each person. Now, there's a lot of, I've given you a lot of detail. If you're interested in Australian immigration law, you can have a look at it. It's on the website, I think it's been uploaded, etc. But it just tells you how many steps you've got to do and what a pain in the neck it is in terms of just having to do with a wealth of paperwork in terms of ensuring that the company, the new entity, is able to be approved as a sponsor. And even if there is a restructure, we would call it a restructure, Greg, whereby, for example, a partnership sets up a legal entity and it's retained what we call an administration company, which employs the foreign workers. But in the restructure, the assets go into the new entity, and we acted for a global company of the ilk of McKinsey. Basically, they had to start all over again because the assets had left the entity. From visa law point of view, the remaining entity was perceived to be a shell, even though it was going to trade off for some period of time for tax and related purposes. The Australian Border Force got involved, would you believe, and they basically decided that no, the approved sponsor was no longer actually operating and trading. It was a shell, so all of their visa holders were at risk. Fortunately, we'd already got in quickly and got the new entity approved as a sponsor because we expected to have difficulties in its environment, and therefore we were able to safeguard the client's interests. So basically, Australia's processes are rather complex. And it really does depend on what the situation is. And sometimes with mergers and acquisitions, you can have a change, but if the new entity is still considered to be an associated entity, you may be okay. I don't know whether other jurisdictions have this concept of associated entities, but in any event, that can impact on what you have to do. And in the event that, in effect, as I said earlier, the merger and acquisition creates a new entity, but it's not associated entity, then you've got to obviously do those steps that I mentioned previously. And just to make it easy for you, in that event, because of our commitment to protecting Australian jobs, as in the case of Brazil, that you've got to quickly do labour market testing, you've got to work with your HR team to do advertising of the positions, make sure you can evidence that there's no Australians that are suitable for the position, etc., so that in effect you can at the end then do a new contract of employment. Say you've done your labour market testing and you can continue then as part of this process to employ this foreign worker.
So would this have to happen after the closing or before the closing?
Well, this is a very good point, because if you've already closed your deal, those workers, and it's a new legal entity, they're not allowed to work. Where are they? They're subject to Condition 8107 or 8607. They're in no man's land. You've got 60 days in which to regularise their status, otherwise, because the company has to notify that there's been a change of ownership. Then you've got to move quickly so that you safeguard their interests before their visa is cancelled.
Right.
So, you know,
it's sort of like a grace period that you have after.
Yeah, up to 60 days, but the employer must notify the Department of Home Affairs, the Australian Border Force, of the cessation of employment because of the fact of the change of legal entity. If you allow your worker to work with an unapproved entity, that's really, you're entering into the land of fines and liability. So it depends on when your visa was approved as to what the rules are. But again, looking, you said let's talk about contracts of employment, terms and conditions. One of the things we do is we suggest to our corporate clients that they enter into contracts of employment whereby they put as much of the liability onto the worker. Because we've got such a diverse workforce and so many people on different types of visas who are not Australians, we try and put some of the risk onto the employer by the way that they construct their employment contracts, so that it becomes a situation where possible that the worker also has a very strong obligation to comply with their visa conditions, doesn't work in breach of their work rights, etc. And we have strict civil liability provisions where if the employer doesn't constantly check the work rights of a foreign employee, that they can actually be liable because there may be changes to that person's work rights that the employer may not be aware of. So I haven't got time to go through the terms and conditions of contracts of employment, but this is sort of a very Australian type of perspective, and it really tells you some of the things that we try and do to try and protect